West, National Trial Counsel for CCW Safe. In this video, we'll start the discussion about what happens at trial. Bottom line is, trial is simply what happens when everything else to get the case dismissed or resolved with a favorable plea has failed. At that point, there's really nothing left to do but to put the case before a jury. There are some cases that can be tried before a judge rather than a jury, but it's rare in criminal cases and usually requires the consent of both the defendant and the prosecutor. I think a defendant is almost always better off with a jury than a bench trial. That's what they call a bench trial, when the judge alone hears the case and makes the factual determinations a jury would make, as well as the legal decisions that are left to the judge. A trial takes place in several distinct phases. The first thing is jury selection, followed by opening statements, the presentation of the prosecution evidence, the presentation of the defense evidence, the jury instruction conference, the closing arguments, and the jury's deliberation. We'll take each of those one by one in more detail, but first it's important to discuss some terms and concepts in a criminal case, so the way a trial works will make sense. Trial terms. Here are some of the most important terms and concepts that you'll hear in connection with any criminal case. Standard of proof. The standard of proof in a criminal case is beyond a reasonable doubt. You certainly heard that before. That means that before a jury can convict in a criminal case, the jury must believe proof of guilt is so great that there's no reasonable chance that the person is innocent. If, after considering and evaluating all the evidence presented in the trial, including evidence offered by the defense, if the jury thinks the evidence leaves open the reasonable possibility that the person is innocent, the only decision is not guilty. In fact, the jury can think the person is probably guilty or possibly guilty, but because of conflicting evidence or evidence lacking in some way that the jury isn't sure, then they must vote not guilty. Proof beyond a reasonable doubt is the highest standard of proof in our judicial system. On the other side, for example, in civil cases, the standard of proof is a preponderance of the evidence, meaning basically 51% on one side is enough for liability. Burden of proof. The burden of proof is placed on the party who the law requires to prove its allegations. In a criminal case, the burden of proof is on the prosecution. The prosecutor has to prove its case and has to convince the jury that it has proven its case beyond a reasonable doubt. If it can't do that, the jury must acquit even if the defense hasn't produced any evidence at all. Because the prosecution has the burden of proof, they will put on the evidence first. They will usually go first at every stage of the case, question the jury first, make the first opening statement, call the witnesses in their case first, and give the first closing argument. However, self-defense cases have a twist on this. Before one can claim self-defense, they have to put on some evidence that suggests they acted in self-defense. When that happens, the burden then shifts back to the prosecution, and the prosecutor has to prove beyond a reasonable doubt that the defendant did not act in self-defense. This is tricky stuff, and another good reason why you want a lawyer who understands this area of the law in particular and knows how to get your story in front of the jury in the most effective way. Presumption of innocence. In a criminal case, the accused is presumed innocent and is not required to prove his innocence or even offer any evidence at all in the trial. If, after the prosecution case is presented, the evidence has failed to eliminate that presumption of innocence, and there's still unanswered questions about guilt, or the evidence isn't completely persuasive, the accused still has that presumption of innocence protecting him, and the prosecution will have failed to prove the case. Of course, many defendants do offer evidence and often testify on their own behalf. They never have to, and they could simply sit by and watch the case presented by the prosecutor and then at the end argue to the jury that the prosecutor didn't prove its case, so they should be acquitted. Sometimes that happens, and sometimes the jury agrees. Thanks for watching. I'm Don West for The Next Fight.